Appeals, First Appellate District of Ohio.
Good morning. Welcome to the First District Court of Appeals. We have two cases to be argued to indicate your readiness to proceed. The first case is FAP Properties versus Griffin.
Good morning, Your Honor. My name is Emily on behalf of FAP Properties. We are ready to proceed.
Okay.
My name is Michael Griffin. I'm ready to proceed.
Okay, thank you. And then Centrifuge versus Pinto.
And Nick Kazanka on behalf of Centrifuge, and we are ready to proceed, Your Honor.
Okay,
Your Honor, Robert Croskery for the appellant. We are ready to proceed.
excellent. All right, so Mr. Griffin and Mr. Himmerly, you may come forward and we'll have the first argument. Mr. Griffin, you have 15 minutes to argue your...
Perhaps 5
minutes.
10 minutes for rebuttal.
I'll let you reserve 5, and you may come forward and proceed when you're ready.
Good morning, Your Honor.
Good morning.
I want to just focus on the fraud that was perpetrated upon me in this entire case. I was defrauded into entering into I was under the impression after answering an ad online to lease property, and then I went and looked at it. It was advertised as 8262 Coleraine Avenue. However, it turns out that that's not the actual address of this property. This property is 8263 Clara, I guess it's Avenue. But I was deceived into believing that I was going to rent this entire property. But once I got to see the property and get into, okay, I desperately need this property because I had recently lost a collision location and was in desperate need to have a body shop for my business to survive. It's not the address. It's a scam that I'm being scammed with, because 8263 Clara Avenue was being actually pledged by my landlord to their lender as a part of their mortgage, where you pledge the rents. They used a separate address to kind of deceive their lender into not knowing they're making rent, that they're not reporting. And I was one of those that fell into that scam that I did not know. Well, I didn't know this until after I was
Signed the lease to the wrong property.
Yes, sir. So here it is. I've reported to the government, to the IRS. That could have come back on me and caused injury to me. It still can. On the PPP applications and things like that, I gave a false address because this is what I thought my address was.
What did the lease say?
The lease said 8262 Coleraine Avenue. So this was a deceptive lease. However, I performed in that lease, which means that everything else other than something simple as change the address to the right address or whatever could have been as that anything that's not, any clause. I did not know that the lease advertised for me or stated that I was to do detailing. I've never done auto detailing. I own Tent Masters, a custom automotive design company where I design cars inside and outside. I don't do car detailing. So when that was brought to my attention by one of the agents of the landlord, I said, ma'am, I don't do that. That's not what I do for a living. So I gave a notice and demand because I noticed that she was trying to set me up for an eviction, because she kept on saying this and kept on saying that and kept on sending me this. And I said, this don't look right. So I finally sent her a notice and demand, giving her a complete list of all of my services, as I also, after the case started, provided for their attorney. However, I was still railroaded out of my lease, sat out in the street, lost my livelihood, and my supplier for my body supplies and paint. And the judge injunction wasn't even, had to read them 2 or 3 times to make sense of them, because I'm just got out of the truth. My prayer today, it's my preparation, but I defraud the disguise of emergency temporary restraining order to say that I was causing them physical harm. The other neighbor got where my tent shop was. Now, if that wasn't, I had full faith in my court system. But I'm devastated. I'm rocked. My world has been rocked, y'all. I'm telling you, it has been rocked. And I'm trying to hang on to my belief in my judicial process. But please read my documents before you make your decision about me. Please read the entire case and see that I was defrauded, and see how the attorney, Ryan Hemley, tricked the other court into thinking that this was not a refile, that that other court case was not a refile, then had my entire appeal for that thrown out. But here I am today, being seen in the appellate court. By my other case, I got thrown out of the appeals court. In 2019, I made $450,000 in 2019 in that location. In 2020, I made over $500,000. Right now, imagine how much money, just so that I could feed me and my wife. I've been hustled.
Mr. Hemmerly. Morning.
Where to begin? At the outset, I would agree that the documents that have been filed by Mr. Griffin are confused. I think Mr. Griffin is profoundly confused as to his role with respect to the commercial lease agreement, and the arguments that he's just raised relative to fraud have never been raised either in his appellate brief or in the lower courts.
You mean the aspect of the fraud related to the location of the property?
Exactly, Your Honor. It's never been a formal allegation. The trial court properly dismissed the counterclaims that were filed by Mr. Griffin. And backing up, I know you've read the briefs, but backing up, this was a commercial lease space.
Mr. Hemley, I'm going to interrupt you for just a moment.
Not raised below as a formal counterclaim. So in his counterclaims, signing a lease, but not relative to the address.
But the inducement to enter into...
Actually said that FAP came along and induced him into signing a lease, and nothing in the counterclaim made certain tenant and for certain non-monetary breaches. And there was a separate count that had been filed against Mr. Griffin and his wife as guarantor, alleged that they failed to pay rent or that there were monetary. He signed the lease as the trustee of this business trust. This is a commercial space that was rented by FAP Properties to Tint Masters, which was the commercial tenant. The commercial tenant eviction action. And so an eviction complaint was filed. The balance of forward rent was accelerated as to the tenant and the guarantor that was due and owing.
So the claim was that he was operating a collision and body shop on the premises, and the lease prohibited that.
And the claim more specifically was that his company, Tint Masters, was operating the body shop, not that Mr. Griffin was representing the eviction action. And at some point, if you accept rent, in this case fraud, alleging that we had made these allegations in the complaint, as well as were there allegations that Mr. Griffin had ever failed to pay rent. And so at the end of the day, but I do want to sort of digress a little bit, even if the documents did say, or it's within a legal pleading, and so it would enjoy absolute privilege. So any way you dice this,
like I said, this case, the refiled case, all of the motions and presentments and pleadings that were put into the case, true that we did not bring up fraud, and that I did not bring up fraud about their behavior or their practices or whatever they were telling me about the address and everything. All of that's within the record. Everything is in the record.
But I think what Mr. Himmerly was saying is that it's not in the counterclaims, that you did not raise the point that you were making earlier about the location being inaccurate in the counterclaim. So do you think that you did that?
I have what they say. Counterclaim 1, plaintiff made numerous false statements and to other persons, some for which was factual statements. I don't want to read. Among the factual statements.
We'll go read it. I mean, don't worry about that. But if there's something that
Yes. Among the factual statements alleged by the plaintiff were that the defendants, Michael L. Griffin, property lawyers and dam, had qualified it to go to the municipal court because you said that it was allegedly $15,000 that I was behind in rent, when in fact I was paying a landlord's account 15 days prior to rent is being due. It was October 15th. That November payment had just posted in their account on October 15th. So not only had I paid October's rent, December the 1st, 2020. So what they did was they waited until they got my November back to us in court. So prior to them bringing that action, my rent, that was fraudulent because it had been paid already till December. Fraud, it's been put in a way where the whole big lie is like when you tell a lie, you got to cover a lie. Tell a lie, you got to cover a lie. And here's where the big lie started. They brought their action. I attacked their action. A notice and demand, which is in the record also, but I sent them a notice and demand letter letting them know to cease and desist from your behavior and what you're doing, trying to intentionally breach and act like I'm breaching. It was notarized, and I sent it to him and gave him a copy, preventing this moment right here. This could have been prevented, but I don't know. I was paying my rent. Not only
You saying you don't know why they instituted the briefs and the records? It was because you were operating a body shop on the premises and the lease forbade that.
they were selling me the stuff, and they knew I was getting it for that. The lease itself said detailing, but I did not know that until I was there over a year or something. I didn't even to have that removed from and establish this is what I do here. Y'all sell me the supplies here. Y'all know I do this here because you're on the premises. There's no reason outside of that. It's different if you don't know I do something. I'm sneaking and doing it. But it's totally different if you... Yes, ma'am.
All right, Mr. Griffin, you're at your time. We appreciate both parties' arguments today. We'll go back and take a look at everything. Okay, the next case is Centrifuge versus Panino LLC.
Yes, Your Honor, I'd like to reserve 5 minutes. Nino Loretto and Panino's LLC in this case this morning, in a best efforts case. That admission comes from Adam Gelter, the patio. But you, meaning, and it's before the court, and he said that in a statement. So there's a lot to this case.
That's this best effort clause in there, but the lease continues even if they never got the patio. I mean, there wasn't an escape hatch.
Because if you don't use the best efforts to acquire the patio,
they couldn't acquire it, then you're still stuck, your client's still stuck with the lease.
Question of fact where the jury can find that they did not use.
But I think, like, I mean, correct me, excuses future
Correct, Your Honor.
performance.
There's an anticipatory breach.
But when did that occur?
Well, it occurred throughout, but the time that it became evident that it had occurred was the time when my clients went to the Over the Rhine Community Council, found out for the first time with half an hour notice that there was opposition.
And when was that in?
That was in 2017, Your Honor.
All right, and were they current on the rent at that point?
Actually, they had brought their rent current as of the end of 2016. Remo Loretto had brought in a check out of his retirement funds for $7,000 to bring everything current. So they had scrambled to make absolutely certain that they were able to continue forward. But in addition to that, I suppose I misspoke a little bit, because the issue of fraud would also have knocked out the lease completely. On the contract, you're exactly right, Your Honor. On the contract, if they use best efforts, then the jury could find their direction. But the issue of fraud still remains. And if there was fraud in the omission in bringing them to a contract that, under the false premise that the Over the Rhine Community Council was not important or would support it, that's not even mentioned, that also would knock out their obligation to pay. Because, as you know, Your Honor, fraud in the inducement means inherently that you can void the contract. It's void or voidable under the
So your argument is that they knew before the lease was signed that this patio probably wouldn't happen because of the community?
I'm saying, Your Honor, that they were well aware that Over the Rhine Community Council opposed this, and in fact, on the record, 3CDC had been there before.
Before the lease was signed?
Yes, Your Honor.
Where in the record is that, though?
It's in the Over the Rhine Community Council records, and the difficulty here is you have to read all the minutes, go through them, which we did with a program searching for public space, Paninos, all those other things, and see where it appears. And the times when there's a representative from 3CDC there in the community hearings, in the minutes, they're discussing the use of, in 2015, and even it's on the record with Adam Gelter saying in February of 2017, when they well know that they have an obligation to purchase the patio, Adam Gelter is saying, we support your keeping this as a public space. They have
So are you alleging that that was lying to the Over the Rhine Community Council and not disclosing the fact that they in fact wanted it for private
No, I think
use?
they were telling the truth to the community council. They were supporting its use as a public space and not as a private space. But they had contracted with my client to make that a private space, to get that patio. And in fact, every drawing that my client ever saw, with the one exception of the one attached to the
Well,
lease.
but I think this client in that property, and if what you're saying is that property is so foundational to the deal, that's the problem I'm having in determining like whether this is a material that would allow you to sue for damages.
I understand, Your Honor, but to determine whether or not it's material, you have to look at the transactions and the testimony of my client leading up to it. The testimony is they were looking at a smaller spot on Walnut, that they would never have taken this bigger space absent the patio, that it was sold to them as being important because of Adam Palazzolo's account, that they were asked to give revenue on a drawing that included the patio, and that when Nino provided revenue, Adam Palazzolo said, well, that's not enough. That's not enough revenue. You're not calculating enough. So on the drawing, and here is our total revenue. And nobody then says to him, well, you know what, you're not going to have a patio, or you may not have a patio. Because the entire momentum of this, and the reason he got his parents involved in it, this is all on the record, to put in $132,000, it had facts, or the omission of a material fact, in this case, opposition that was knew how significant this patio was. And when he knew how significant it was, this is in April 29th that it's signed, that the lease is signed. So he meets with Daniel Betts when he first comes in. Now, the lease obligates him to buy the patio.
Well, let me ask you this too, and forgive me if I just am hung up on this, but I mean, there's no timetable in here. Usually, if you're saying like, hey, this has to be done, and this is like foundational to the agreement, it would say you must do this by X date. So like, conceivably, be compliant with the lease.
Well, I suppose you could say that, except that Adam Gelter, the point man, stated at the very beginning he knew that that patio was supposed to be there at the time that they opened up. And that's why the drawings that were approved by the health department on May 24th of 2016 showed a patio in it. That's why the discussions about the patio were so important to my clients. They were ordering patio furniture. Adam Gelter admitted that that patio was being postponed till the next spring so they could pour concrete. What she should have said was, we don't know that we have the patio, because at no time did Adam Gelter ever bring up the lease to Daniel Betts, the director of CRC. At no time did Adam Gelter, the point man, ever talk to the Ohio Over the Rhine Community Council and say, we have a contract that obligates us to buy this land and put in a patio there, to use our best effort with multiple parties. That's the reason why my clients were deprived of it. Were they wrong to rely on the word of 3CDC that they were going to use their best efforts? Nominal record. One where if they actually did expend their best efforts, it was as good as gold. It was as good as guarantee. So if you look at the facts and circumstances, and I think
on evaluating your best efforts argument.
if you're asking how would I instruct the jury,
Yeah, you get to draft the jury
all right,
instructions. What do they say?
then my jury instructions would reach the fault, would be right out of Black's Law Dictionary. Made all actions rationally calculated to achieve their objective of buying the patio to the point of leaving no possible route to success on the defendants. If, on the other hand, you find that those efforts did not reach that level, you should find.
Okay.
So, getting back to the point of sitting down with Daniel Betts at the very beginning, that's key, because Daniel Betts testified that in this case, it cost $245,000. And what the real Betts, he said, look, I know you're new here. You may not know everything about this town, but we do have a contract to use this land, and we need a price on it. That's the time when that should have started. Whether he was going to sell it or not was immaterial. If they were using their best efforts to get this patio in by the time the restaurant opened, there should at least 2 weeks. If that had been done when he first met with them, then by mid-July, there would have been an appraisal. Best efforts to acquire the property. Because if they had been using their best efforts, they would have let Daniel Betts know. Let's get this appraisal done.
Well, wasn't Betts concerned about there was community opposition to this? AC to care about really community opposition because they thought they had a deal, right, with CRC?
I'm not sure whether they thought they had a deal.
Or they thought they were going to get a deal. A lease was signed.
If 3CDC had not continually been going to the community council for other issues, there might be more force in that argument, Your Honor. I think what the testimony in the record is that Adam Gelter had stated that he had talked to Steve Pasella and to Mr. Stiles and believed that there was support from Sphere at that time when there was a lot of conflict. And I think that's
Alleyway or park, 2, 3, and then and he's like, no, we need to get the community council on board.
Well, I understand that argument, and I think the jury could certainly consider that in determining whether or not best efforts were made. But if you look at the actual decision making, they received the appraisal. And at that point, Daniel Betts said, oh, that's great. He says, we'll sell it to them. Let's $245,000. That sounds reasonable. Now, at this point, or 4th, I believe, that's in the record. But what happens after that is for the first time ever, Daniel Betts expresses that he is interested in getting this community opposition, but they don't tell Nino about it even then. Nino had the
On his own. I mean, I'm struggling with that argument simply because that was public, no? I mean, any opposition, couldn't he have found that out himself? I mean, did he have to be informed by?
I think that there was a duty to inform because of the significance of this decision to buy the land. He's just anything wrong. He's been told he's going to get the patio. He's been told to buy patio.
Publicly.
She did, but she did that before she told him the patio had been approved. And the patio, basically just running it without pay. They're spending a whole lot of their time invested in the day-to-day operations of running a brand-new restaurant that doesn't have adequate liquor sales because they don't have the patio they were promised to start with. So in one sense, I think it's unreasonable, although it certainly would be a jury question. I think 3CDC is welcome to argue that to a jury, but I think it should be in front of a jury so they can weigh the relevant facts, determine, number one, whether all best efforts were used, number two, whether those efforts were sufficient and would not have mattered anyway. I think Judge Bergeron's point is well taken, as they can make that argument. But I don't think that it's something that should be decided as a matter of law by the court.
And Mr. Crossgray, we've taken you well past your time, but I'll let you reserve your 5 minutes.
Thank you, Your Honor.
Thank you. Mr. President.
I can always address it in my opening argument as well, but I would like to maybe reserve 2 minutes.
Yeah, that's fine.
Okay, may it please the court, Mr. Crossgray, Nick Pazonk on behalf of the appellee Centrifuge Landlord LLC. I'm here with Caitlin Felvis of 3CDC.
Can you start with Judge Bergeron's concern about, does this best efforts, if somehow it's found that 3CDC did not use its best efforts, does that negate then the entire lease contract?
It does not. So if it's found that we breached the best efforts, yeah, I think future performance would probably be excused, because that would be probably a material provision of the lease. But there is no out in the lease. And I want to point out the fact that Mr. Loretto was represented by counsel during the lease negotiations. So there were drafts of the lease exchanged back and forth, and they had every opportunity to bake into the lease some out, that if this didn't happen in the future, here's what you
There's no
the jury if they're Ohio law. There's one case, it's the Bridgeland case, and it's out of contempt proceedings from a mortgage. And what the court did in that case, is here's what the court then went on to say in the very next paragraph, and I'll quote, is that density. And I think that's important. Flexibility and reasonableness. In the other cases that we cited, one from the Northern District of Ohio, that's the business health case, says reasonable efforts and due diligence. And then the
What's the difference between that and just the good faith requirement that's in every single contract?
So that's answered by the Mark Technology cases that we cited. And what that court said is that good faith has baked into it honesty and fairness at its core, but best efforts has diligence at its core. So these are the steps that you are taking to achieve a result. And what the AAA baseball case says is that property
Because they're going to argue that they're not. But doesn't the nature of this best efforts really lend itself to a jury question?
It does not. And there are numerous cases that we cited in our brief where courts have granted summary.
Yeah, but those were from like Minnesota and other far-flung jurisdictions that, like, I didn't see Ohio law saying this is squarely should be decided as a matter of law.
Hence my point of being it's not really well developed, and looking for your honors to develop that case law.
Fair.
And that's why we cited to a number of cases outside the jurisdiction. Your honors to the Kallenberg case that we cited. So in that case, it was a best efforts to provide financing or to obtain financing. And the seller claimed that the purchaser should have fired their first broker. The purchaser didn't use its best efforts to get this financing. They failed to seek industry review of their first appraisal. They should have contested it. They should have applied for financing under the spouse and they should have used cash as part of that financing. And what the court said is the seller presented no should have gotten it, but
And I think I understand this, that there's like some sort of but-for causation.
And the nail in the coffin on that is you have testimony from both Daniel Betts and Maurice Wagner. This with more just did not. This is exhibit is Mr. Loretto with him in Cincinnati Recreation Commission. And then I ended it and I said, it's still your position. That timeline words after the lease is signed, Danny Lipson, who's with 3CDC, tells so. It's no secret. We wanted to do this, and that's the specifics that this was important. Now, if I can at least talk about a couple of the facts, entities to purchase the land. Not best efforts to purchase the land. It's best efforts to obtain the approval. 3CDC knew that there was significant pushback from the O the Rhine Community Council that this was just not going to happen, and that's not the case. I implore your honors to search the record because that's not in there. What you will see is October 12th of 2015 meeting minutes were a portion of the alley.
In October 2015,
Loretto, so they were getting in front of it, of saying that, this is something that we wanted this at a later date. So it wasn't, no, this is not absolutely happening. They had the votes in favor. So you move to May of 2016. That's when 3CDC immediately reaches out to new director Betts. July or Lisa to delicately ask, CRC, where do you stand Please speed it up. This is important to us. They have to do that delicately. CRC realizes that a coordinated report, Director Betts being new, didn't realize that that had to be done. So they've realized that, then ordered the appraisal. The appraisal comes back in mid-September of 2016. Then October 2016, CRC's weighing its options. And then November 2016, and I think this is critical to 3CDC. That is proof right there that 3CDC is using its best efforts to obtain the government and the community's approval.
But it was contingent on,
Director Betts emails Adam Gelter and says, I want to talk to you about Ryan Community Council. Director Betts said in his testimony, I'm new. So at that point, 3CDC, along for the results in the charrettes that you probably see in the record, the community meetings held in May of 2017. The important thing to note there is that CRC told 3CDC, this is our show.
You should have involved
They knew.
Well, no, but that you should have involved them and invited them to the meeting so that they could put like a human face on it.
So Mr. Wagner, Maurice Wagner, says that they don't want owners involved in those meetings because they're biased. They want a fresh set from the CRC in the community, what is the plan, and not have that biased in any way, which is probably why 3CDC wasn't asked to take a specific role, an active role in that meeting.
they don't want the owner, the face of the business that wants to put a patio there, to tell the community why it would.
Loretto.
It was fairly close, at least for part of the alley. I mean, not for the whole alley, but at least for part of the alley. The vote was a lot closer than what, I mean.
So at the charrettes, yes, I will concede that. So, but this involved much more than the charrettes. So the charrettes were the two meetings, and it was May 17th and May 24th.
Mm-hmm.
But after that, what CRC also to the public, and it was hundreds and hundreds of votes of what to do with it. So it wasn't just as close as, okay, 20 to keep the CRC reversed course. So they were intent to sell it to 3CDC because this is mission
To finish it.
three things available for a new evidence on the file we gave the no. So
Just the time and the money.
You have to establish the,
cents on the dollar. Know that there is okay based on the attorneys that are in front of me, the hourly rates.
The work that was done, who did the work? I mean, specifically.
That's not what did rate can say. Okay, you charge too much. Therefore, I'm going to cut your rate to this. But I see that a lot of work went into this case, and therefore, you know, here's my award, and this is what's reasonable. So, but it's our position that that can't be zero. And is it the 220 that we want? Maybe, maybe not. But the
way it's not.
plenty of cases provisions.
Okay,
So, unless your honors have anything else, that's all that I have. Thank you.
thank you. Okay, Mr. Croskrey, rebuttal?
Can I zero you in on something before you start? So let's talk about CRC and Over the Rhine Community Council said that nothing would have changed their mind about supporting this project. And I remember when I was reading through this that they were not going to support it, period. Can you address that? I mean, does there have to be prejudice here?
Well, yes, there would have to be prejudice, but one question is, at what point in time are we talking about? Because the best effort delivered at one point might deliver it, where point to 2016. That's clearly malarkey. There is a very good chance that the element out that has been in there's lots of good arguments that could have been made, should have been made about purchasing the land. What the clause actually says is purchase the land and manage the installation of the outdoor bar and service area. I'm pretty sure the government and the community agencies are not going to be managing the bar and service area. That will be Nino, assisted by the landlord. So that's a false was that Daniel Betts didn't know what was going on because he was new and didn't get any important. For 3 whole months during the summer, or actually 2 months and 3 weeks, 2 months and 3 weeks, there is no communication, but they helped getting that needed to be done before they could get the land and get this patio done in time. That's why I say there's a very good jury question here about whether or not the best efforts were used, because there's some questions whether any effort of any significance was used. Third, if you go to Black's Law Dictionary, And Judge Bach has it correct here. There must be a difference between good faith and best efforts. Because if there's not, there's no fiction.
Yeah. Question, maybe if things had happened a different way earlier, like, does that ultimately get too far down the road of being speculative?
Well, juries have to have a rational basis for their decision. And it's important for us to put the rational basis for thinking that good efforts would have made a difference in the record. I would certainly agree with that. But to the extent we can put that, could say, if it's involved
Mr. Leeper.
to do anything, is that a reasonable effort? Could that reasonably accomplish the goal? And if they weigh the evidence, which this court should not do, but which a jury does, and says there's a rational basis for it, so we find that, yes, not using the best efforts led to harm. And
But
the harm is
there anything in the record that even indicates that if 3CDC had done things differently, then they would have been successful?
yes.
Okay.
First of all, there's the testimony I was just alluding to, that 3CDC has almost an unblemished record of success.
On anything within this project that you can point to that?
Well, Your Honor, the jury to some degree always is looking at what would have brought about the eventuality of success.
But that's really based on their history of success.
And could a person would have responded to it. It's based upon more than an assertion by one over the Rhine that were customers of the restaurant. If they showed up, if he'd known about it and sent them, would they have made a difference? Would they have said, we love this restaurant. It's filling an important goal. These are all jury questions. So we cannot stand here on the bench and say, as a matter of law, there's no way that let them do their job, weigh it and say, is there sufficient evidence that that's 87,000? If the
Crosker, you're well past your
I'm sorry,
time,
Your Honor.
but we peppered you with questions, so thank
Thank you,
you.
Your Honor.
Yes.
Thank you, Mr. Croskery. May it please the court, unless your honor's here for rebuttal, so that's pretty much all that I have.
Okay, great.
Thank you.
And then hope you all have a great day. That concludes court for today.